So, of course, we're following the breaking news. The Supreme Court has ruled that former President Donald Trump can appear on the 2024 ballot, overturning Colorado's ruling.
Now, the decision comes after debate over whether the frontrunner for the GOP nomination violated the insurrectionist clause of the 14th Amendment of the Constitution. And so we're continuing our coverage of this breaking news. Again, the Supreme Court has ruled that former President Donald Trump can appear on the ballot in Colorado. This decision, of course, comes on the eve of Super Tuesday. Colorado is one of the states where people will be taking to the polls. So CBS News chief legal correspondent Jan Crawford is in Washington, and also CBS News chief election and campaign correspondent Robert Costa is joining us. And here in Studio 57, CBS News chief Washington correspondent Major Garrett is here. All right, Jan, let me begin with you. We've been sort of going over the decision that the Supreme Court made. You reported earlier this morning on CBS Mornings that you would not be at all surprised if the decision was unanimous.
Right, and it was. I mean, the decision itself wasn't unanimous. They had slightly different reasons for the justices did, but the bottom line is this court agreed unanimously that the Colorado Supreme Court got it wrong, that states can't look to that clause in the 14th Amendment and say, we're going to be able to disqualify a presidential candidate from our ballots, that one state or a handful of states can't dictate the outcome of a presidential election. That's not what the framers ever intended when they wrote that or when it was passed, of course. So the bottom line is that if you're going to beat Donald Trump, it's going to have to be at the ballot box, not through these state efforts, whether in courts or by officials, to disqualify him from the ballots. I don't think this is a surprise. The Colorado Supreme Court was kind of off on this trip of its own when they released this decision, which was 4-3, narrowly decided. And it was the only court that had reached that decision up until that point. And then, of course, when we saw arguments last month, I think the justices signaled very clearly that they were skeptical of arguments that states should have this authority and kind of the havoc and chaos it could wreak if they did.
And, of course, there are other states that have attempted to use the 14th Amendment to do the same thing. So that kind of puts that to bed. But I guess my question is there wiggle room? Are there other arguments bubbling up that we may see working their way through the courts that would also attempt to remove his name from the ballot?
No. But I do think, to your point earlier, Vlad, in the question about whether or not Trump's going to try to make this like, look, the court has cleared me, I'm not an insurrectionist. I mean, he can make that argument if he wants to, but there's nothing in this opinion that suggests that he should be saying that. And furthermore, there's a case that the court's going to hear in April on whether or not he can be tried for his actions around January 6th. So this is not the last word that the Supreme Court's going to have on Donald Trump. And while today he's walking away saying the court is a beautiful thing, like he said after the arguments, he may have a very different tune in April, where I think the court in April, in that case, is probably going to come out the opposite way. I do not think Trump is going to be successful with the sweeping arguments he's making in that case, that he should be immune from prosecution for his actions around January 6th.
So, Bob, to you now, before we bring in Major, what we've been talking about what this might mean for how President Trump, former President Trump campaigns. What does it mean for his base? Does this galvanize them even further?
In just the last few minutes, Vlad, former President Trump has issued a statement on his social media platform calling this day a victory for him, his legal team, his campaign. But to build on what Jan was saying,
while this might galvanize his base and make them feel heartened that he is going to be on the ballot across the country, he faces a storm on the horizon, whether it's the hush money case in New York that starts later this month, the ruling on immunity set to come sometime after those April 22nd arguments, late April arguments. And this is a campaign, though, that while former Ambassador Nikki Haley won the Washington, D.C. primary election in recent days, ahead of Super Tuesday, it's Trump who is not only galvanizing his supporters, but he is really getting command of the party, taking over the Republican National Committee. And his campaign, his legal team, feel like they are going to have to spend millions of dollars in the coming months to deal with all of these legal issues. But he's positioned with his fundraising to address all of that.
Major, just to talk about the political implications, Jan said that according to the decision by the court, he can't say he's not an insurrectionist. Right. But I wonder whether he calls himself an insurrectionist or not. Does it even make a difference? Because is it somewhat of a badge of honor anyways for him?
For Trump supporters, it doesn't matter. They've already decided he's not.
Right.
Some have already decided that was an act of patriotism. Whether the rest of the country agrees with that or not will be one of the themes of the 2024 campaign. But let's just step back for a second. Why are we here? Why was there no implementing legislation passed by Congress after the Civil War? Because that massive, bloody trauma was never imagined again in this country. Congress did not feel compelled to specify what insurrection was because it never imagined we would be faced with that definitional, syntactical problem ever again. We are here because we now have to decide what January 6, 2021 was. To some Americans, it does look like, it's certainly a riot. Was it a riot to stop the peaceful transfer of power? Is that an act of insurrection? This country is debating that. We're here because of that day. Yes, there's no implementing legislation. That's where the court came down. So that's one aspect of it. The court's also making sure that voters are not disenfranchised. Just recall, if President Trump, when he was in office fighting the 2020 election, which he fairly and legally lost, if he had prevailed, he would have disenfranchised millions of voters, his own and Biden supporters, in 7 states. So the court did not go with that, so it's protecting voters on both ends. Third point. The former president right now likes to say, and we talked about this earlier this morning, about being the victim. He cannot call himself a victim of the legal system now. The legal system worked. Voters in Colorado had every right to ask their Supreme Court, was he an insurrectionist? They were, under state law, allowed to ask that question. It went through a trial. The Supreme Court made a decision in Colorado. Now it's been overturned. Nothing was askew legally. Everyone was pursuing the law as presented in their state, and now the Supreme Court said, you know what? We can't do this. So now everyone has clarity on that. But these questions arose because of something that happened. A galvanizing moment, an unforgettable moment in our history that the former president owns, legally, politically, ethically, and morally. And that will be a part of our campaign.
Jan, let me ask you before we wrap up. Do we still have Jan? Yeah.
Yep, I'm here.
Jan, so
I was enjoying Major's analysis.
No,
that was
yeah,
that was
fabulous,
really good.
Major.
We're
I was
so
like, gosh,
lucky.
I hadn't thought about that. That's a really good point.
No, we're so lucky to have all three of you here to break this down for us and for our viewers. But Jan, you mentioned that looming on the calendar is April, when the Supreme Court is expected to weigh in on Trump's sweeping immunity claims.
Yeah, they'll have arguments that week. They haven't set the exact day, but they're going to have arguments. It's going to be quite a show. I would not be surprised if Trump attends those arguments. And, of course, you can imagine the scene outside the court that day.
Absolutely.
That's going to be whether or not the special counsel, Jack Smith, can essentially go forward with the prosecution.
So here's the question, Jan. I've seen some argue that setting the date for those arguments in April was a win for former President Trump and his lawyers because it may perhaps push this trial past the election. Again, which would then not give the voters all the information that they need to make a decision as to who they want to vote for. And I've seen others saying, look, the way you just surmised, that perhaps the court will not rule in former President Trump's favor, which would have huge, huge ramifications no matter what is happening on the trial front. How do you see it?
Well, I mean, first of all, the Supreme Court has expedited this case. I mean, that's what Jack Smith asked for, the special counsel. He asked for a decision this term. He's the one who asked the Supreme Court to take it up, not Trump. And he asked the court to expedite it, and he asked for a decision this term. He's going to get that. So I think it's kind of hard to argue that, you know, what's the court doing? They're just delay, when they're literally doing what the special counsel asked for. There's going to be a decision this term. The question is, why did the Justice Department wait 30 months to charge Trump? And we're in this position anyway. I mean, that's not up to the Supreme Court. So they're doing this in a very fast manner. If they put it on their regular docket, they wouldn't have arguments until, you know, next October, November. That's how they're doing the cases now that come up to the court. So I think that's a hard argument to make. I think these arguments are going to be very complicated. This one, I think, was more clear today that we got. It was pretty obvious what they were going to do. The arguments were pretty extreme. Trump is making a sweeping argument on immunity that obviously the district court, the appeals court rejected. That's what the Supreme Court is going to review, that he is absolutely immune from prosecution for his official acts as president. I don't think the court will embrace that. But again, they may have different reasons for why, and they may have some kind of qualified, there may be some acts that a president can be prosecuted for. Maybe there aren't others. So this one, I think, is going to be a little more complicated. But again, I think that the outcome is going to be that Trump is not going to be as happy after that decision comes down as he's going to be today.
And then the courts will be corrupt. And it'll be a witch hunt.
Right,
Whatever
right.
works for the campaign.
Yeah, exactly. And so, Bob, this question, you've covered Washington for a long time, and Major, you can perhaps weigh in on this as well. The Supreme Court, again, sort of saying that Congress, by a vote of 2/3 of the House, can remove such disability. That's the language that they're using, right, when it comes to how the Constitution is interpreted with regards to the 14th Amendment. Given where we are in our politics in this country, is there anything that could ever be passed in a Congress where you have 2/3 of a majority that agree on something other than benign, like, federal holidays or, anything that has real teeth in it? I don't know. I'm trying to think here.
Well, my motto as a reporter is to assume nothing. And at this point in American history, I don't rule anything out. It was just a few years ago we had an impeachment trial in the United States Senate about an attack on the Capitol and the President of the United States and his alleged complicity in an attack on the certification of an election. We use that word unprecedented a lot in our politics. So at this point, with a deeply divided Congress and a deeply divided nation, it's very unlikely there's going to be some kind of 2/3 majority coalition on removing someone from the ballot or having some overhaul of how we put people on the ballot or elect presidents of the United States. But at the same time, we're living in such a convulsive age that if Congress does start to react a bit different on presidential conduct in the coming years, you could see more Republicans moving away from Trump should he push the norms of the law and politics to the extreme in a way that's seen as necessary for Congress to take that kind of dramatic action. But you're right in the sense of your initial assessment is that there's a very small percentage chance that Congress ever moves in that direction, at least now. But again, assume nothing.
But Major, Congress did have an opportunity. I'm watching, Mitch McConnell give speeches about his retirement. I'm reading articles about this legacy that he has. He is no fan of former President Trump. In fact, some would say that they're completely at loggerheads right now, even though he used Trump as a vessel to get his Supreme Court justices and 200-plus federal judges appointed. He could have stopped them.
He was critical after January 6th.
He was very critical. Could have stopped them with
critical after Trump had not been convicted.
Right. You could have convicted him.
Right.
And he would have not been eligible to run for president.
Precisely. To your question that you posed to Bob a second ago. So you raise a very interesting, both constitutional and political question with that. So the way the 14th Amendment, Section 3 is written, many scholars, and I've read many of the briefs that were given to the court defending what the Colorado Supreme Court said, that because what that section is about removing this disability by 2/3 vote, that is where Congress decides someone who is an insurrectionist can be elected and can serve. So they remove your insurrectionist past, they cleanse you of it by a 2/3 vote, okay? And many constitutional scholars and historians wrote the Supreme Court and said that proves this is self-executing. You don't need enabling legislation from Congress. Congress wrote in there that it will be obvious that this is an insurrectionist act, and then Congress can look at it and say, well, you were a minor league player in the insurrection. You were not the leader of it. You weren't Jefferson Davis, the president of the Confederate States of America. And we can, through congressional action, remove that disability, remove the thing that is disqualifying you from holding office in the American system. So what the court said is, no, that isn't self-executing. Congress hasn't been clear enough. The amendment doesn't read as it looks like it reads. And then you ask the political way, well, can Congress agree on 2/3 of anything? Not both houses. Maybe one house, maybe the other on one thing, but not together.
Yeah. Wow. It's fascinating. And we got a history lesson.
Love it.
Jan Crawford, Robert Costa, Major Garrett, thank you so much, guys.